So what I wanted to talk to you about in this session is really just what we've been doing, what's been going on in the last 2 years since we last met in 2019 at the conference. And so, as we all know, the construction sector has been really busy. There's been no shortage of work. And we lawyers have also been pretty busy too. A lot of it has been drafting contracts. And as Matthew sort of alluded to earlier, a lot of those COVID clauses we've been busy drafting. And a lot of disputes, as many of you in this room will know. And the courts have even had to, and the courts and adjudicators have even had to embrace virtual hearings and electronic bundles and all the rest, and finally get up to date. So, but what I want to talk to you about here is firstly the updates that we've had to the NEC. Mark's already mentioned X29 or the draft X29, so I'll go through that. The new clause on reducing the impact on the works of climate change, which is a nice, catchy title. Also, the October 2020 amendments, which may have perhaps slipped under the radar for some. And just a few cases, because there's actually been a lot of case law coming out of the woodwork that is NEC related now. We are starting to see a lot more of it. And there are a few cases that I want to talk about that actually talk about the interpretation of some of the key clauses that we have all come to know. And in particular, building on what Bob was saying on the spirit of mutual trust and cooperation and how that's been interpreted. So, first, climate change. It's the hot topic, excuse the pun, and it's everywhere right now. And it's in our day-to-day lives. It's on the news. It's the sort of government commitment to 2050 net zero, which may or may be achievable or not. What we have seen traditionally is that this has been dealt with in the technical documents, in the scope, the works information, the specifications. And it's something that all contracts need and projects need to be looking at and need to be considering. And there has been a growing view that actually including something in the core conditions can actually be used to support and perhaps even incentivise measures that can reduce the environmental impact that we're having in the methods of building and the actual end result of the asset that's built. It hasn't really been, there haven't been many standard forms that have actually done this. Most of them perhaps have a very brief allusion to complying with environmental requirements or something, and then everything's left to the scope. There are some specific, the Chancery Lane project actually, which is it's a collaboration of multidisciplinary lawyers. They've actually built from some very specific clauses which deal with specific scenarios such as compliance with environmental regulations and procurement of materials. But it's a difficult task because it's obviously it's country specific. It's dependent on the local laws and regulations. It's project specific. Each project has different environmental concerns. So what have NEC done? NEC have developed a draft secondary option, which is actually released on Thursday at their conference. And there was a consultative draft out from the 4th of April, draft X29. It's intended to be used with all of the NEC main forms, but I think the draft version was only sort of for the engineering and construction contract. And from a first glance of this, the intention is obviously to make it as broad as possible so that it can be adapted to different projects across the globe. And also it's a sort of a one-size-fits-all approach. And the hope there is obviously that it will encourage wider use of climate change initiatives by having that option there and ready to use and to be built into. But what does it involve? It requires the parties to have or to have some climate change requirements that are to be stated in the scope. So that's not too different to what we've been sort of seeing and hearing about and what Mark was actually mentioning earlier. So, but these requirements, what they do is set a minimum level for the contractor to achieve, and a failure to do so would be a defect by not providing the works in accordance with the contract or in accordance with the scope. And so that would need to be a defect that would be corrected, and therefore it could be usually at the contractor's cost. So it's still heavily relying on the technical requirements being included, And the key point there is making sure that those requirements are appropriate and achievable. And don't place undue risk on the contractor and hinder progress or productivity or into the contractor's margins either. It's not specified who's going to be preparing that in the draft X clause, but it could be something that the client perhaps sets when they define the scope. It could be something that they request in the tender period for bidders to suggest, or it could be developed collaboratively between the bidders or a contractor and a client. So we've got those requirements. And then there's another layer which I think we also saw from Mark's earlier talk, it seems to be a similar concept, the performance table. Now this is intended to allow the client to include flexible targets related to climate change. It's an extra layer to those original climate change requirements. And the contractor is encouraged to achieve these targets by it permits you to include positive or negative financial incentives. And these are outside of the cap on liability. They're an excluded matter, so that they're not going to sort of eat up all of that. And in some ways, it's sort of a combination of secondary options X17 with low performance damages and X20 key performance indicators. And the guidance notes that accompany the draft X clause suggest that it shouldn't be used in conjunction with those. So we have requirements, we have targets, and what else do we need? We need a plan. And the draft X clause does provide for the contractor to prepare and provide a climate change execution plan, which sounds like quite a grand name, really. And so the form and content set out in the requirements, so that's all sort of up for grabs. That's all for the client to decide and tailor to the project. And obviously the key to this is to set out the strategy for how the contractor is intending to achieve those climate change requirements and those performance targets that are in that performance table. I think it's actually intended to be included in the contract data. So that's something that would perhaps be accompanying the tenders at the outset, or at the very least, it's supposed to be provided within a fixed period after the contract date, which sounds a bit like the sort of programme requirement that we're used to seeing, but there isn't actually any type of financial sanction if this isn't done. Which perhaps is something that may have been raised during the consultation, given the importance of actually having this plan, of achieving these requirements. So I think it's having this kind of plan. This plan can then also be updated throughout the project. And it's a similar sort of concept, this type of plan, as to the sort of information plan under the BIM type clause at X10, so information modelling. What else do we have under X29? We have other things that we would expect to see. A lot of tying into a lot of the other clauses. So we have collaboration. Obviously, it wouldn't be an NEC clause without some form of collaboration. So there's a requirement to collaborate with other named climate change partners that are identified in the climate change requirements. Early warnings also need to be notified if there is an event that occurs that is going to perhaps prevent or hinder the achievement of the climate change requirements. So it's good to get that notified early. There's a requirement for a disclosure clause which allows information relating to climate change to be shared. And this is really particularly important because it's recognising that many public and private bodies are obliged to publicise their climate change data and information, and may also need to obtain that information from their supply chain. Acceleration and accepting defects and compensation events, any quotations are to include any proposed changes to the performance table that may impact on. And there is also a mechanism to adjust for the targets for an event which only impacts the performance table itself and would therefore not otherwise be triggered by any of the other compensation events. So it's essentially a new ground for a compensation event. contractors' proposals. The contractor has the opportunity to give proposals and come forward with good ideas to reduce the environmental effect of the asset, not only just at the outset in terms of building the project, but also in terms of operation and maintenance going forwards, which is obviously key to sort of net zero emissions. And if the proposal is accepted, then the scope, prices, completion dates, etc. are adjusted. There's also a regime for measuring performance against the targets in the performance table and proposing improvements when the parties are alerted to a failure or a forecast failure, which I think is quite important as well. So it's sort of sticking with this sort of early warning type ethos that we always have in NEC. And as I already mentioned, the financial caps, the financial sort of incentives that are in the performance table are excluded matters under X18. So, I mean, it remains to be seen on Thursday how much the drafting will change and whether it will change from any of these key concepts that I've tried to sort of bring out to you here. But it's very clear that it is intended to be very flexible, a one-size-fits-all approach, in order to make it work across the different contract forms and a variety of different works and services, with different industries and different projects. And this approach still does rely heavily on the parties working together, working collaboratively, and including adequate content in those climate change requirements, and also in the performance table. And proposing innovative financial incentives to really encourage compliance with these clauses. It's unclear who will be responsible for drafting the requirements and targets at this stage. I don't know if that will be clarified later this week. But again, it may well be that that's something that, again, is quite appropriate to certain projects, that it is left silent here. And on some projects, it may be more advantageous for a client or a contractor, or perhaps some will be fairly straightforward because there'll be industry standards that can just slot in quite nicely. There is a risk that if there's so much work to be done by the parties, that the clause is perhaps too broad, and perhaps parties will opt for a purely bespoke approach, as many of them, including the Environment Agency, have already been adopting. Though it's good to hear that Mark said that X29 has their full support. On the other hand, anyway, having just an option clause in the contract acts as a good reminder to the parties to include these provisions and provides a basic framework for them to start from. And more importantly, it builds the requirements into the contractual framework as well. It was good to see the links to all the other clauses within X29. So we look forward to seeing the final version of this later this week. So X29, as I said, isn't all that the NEC have been drafting away over the last couple of years, and there were some further amendments to NEC4 that came out in October 2020, and I just wanted to remind you of just a few of those important ones. So the first one I've got here is on the slide is X7, the delay damages clause. So this clause, obviously, I think we probably all know this one pretty well. And it provides an obligation to pay delay damages if the completion date is missed, and that runs from the completion date until the earlier of completion being achieved, or the client taking over the works, or what has now been added is the issuing of a termination certificate under the contract by the project manager. And this means that the period in relation to which delay damages are payable, where the works are unfinished, now expressly ceases on the date of that termination notice. And after the date of termination, further delay costs will be considered as part of general costs or damages resulting from the breach of the contractor's obligation to provide the works. And whilst this was generally the understanding at common law, there was it appears to be a response to a Court of Appeal decision in 2020, the Triple Point case. And in this case, there was a clause that was similar to the NEC4 delay damages clause as unamended. And it didn't have any reference to termination. And what was held, it was held that it was inapplicable on termination. So if the works were never completed or never taken over or accepted by the employer, the delay damages clause would fall away. And then it would just be general unliquidated damages that would apply for all of the delay. This was considered an unusual decision at the time, and it was actually subsequently overturned by the Supreme Court, although the the October 2020 amendments had already come out. So there has been some sort of commentators saying that this has perhaps been, NEC perhaps jumped the gun here by issuing this amendment. But on the other hand, there's no harm in having this common law position clarified, but it's just a position to note that that's now the new position under NEC4. It's not really a new position, it's what it was really under common law. What it now is definitely under common law, but it does perhaps protect against another future rogue decision, or perhaps if it's used in a different jurisdiction where that wouldn't apply, where the triple point case wouldn't apply. So moving on now to another option clause. This applies obviously purely to the UK. It's a Construction Act payment clause, and this amends the professional services contract, term service contract, design, build and operate contract, and their related subcontracts. And basically any forms which link the final date of payment to submission of an invoice. So the amendments mean that the due date is now stated to be the later of the date of receipt of an invoice by a paying party, or 14 days from the assessment date. And the final date for payment is a fixed period of time from the due date and no longer runs from the date of receipt of an invoice by the payer. It's important to note it doesn't actually change the timescales of the payments at all. And the amendment here appears to be following a decision in Rochford Construction and Killen Construction, which confirmed that the final date for payment must be a fixed period of time from the due date and cannot be linked to the provision of invoices. And I just think this is particularly important because if any of you are working to the previous versions of this clause, it may just be important to note that there is a possibility that if it doesn't include, if it does link that final date for payment to provision of an invoice, then it could be that the scheme actually applies rather than your contractual provision. Right, so moving on to the project bank accounts clause. Project bank accounts have had a few mentions already today. It's had a bit of a makeover. And now, so the account holder can now be the contractor, or it can be held jointly by the contractor and the client. So it's giving the client the sort of option to decide how much day-to-day involvement in administering the project bank account it would like. The other updates include reflecting electronic banking methods, which obviously is very much used and has been very much used over the past couple of years with COVID and lockdowns. The authorisation document has now been replaced with a payment schedule, and this is to be prepared by the contractor, and the payment schedule should list payments that are to be made by made from the project bank account to the contractor or the named suppliers. And there's also a project bank account tracker with a register of all payments made to and from the project bank account, stating the date that they're all each made. And so these amendments apply all to across the NEC suite, wherever this option is to be used. And this one wasn't a reaction to case law. This one actually is a reaction to user feedback and best practice, and it's intended to just update the provision in accordance to how it's being operated. I won't mention too much about early contractor involvement. It's had a little bit of an update in the October 2020 amendments as well, just to provide a bit more flexibility and a bit more structure in the process for how you get from sort of stage one to the notice to proceed to stage two. And I know that Neil and John are going to be talking a lot more about that in their workshop this afternoon. So now moving on to the exciting world of case law that we've had over the last couple of years. That's just a list of a few of the cases that I was going to mention. And the important thing about this is all actually testing the wording of NEC. It's not the sort of cases that we've often seen where it's been an NEC contract, but it's not actually been, it's been a sort of an adjudication decision being challenged in the courts. This is actually the NEC wording being tested and often upheld and enforced, which I think is quite important. So the first case I want to mention, which is particularly good, it looks like we've planned it well following Bob, because this This case relates very much to the interpretation of Clause 10.1 and the spirit of mutual trust and cooperation. And so in this case, Van Ord were engaged as a subcontractor to carry out dredging works in Aberdeen. It was part of a bigger project creating a new harbour, and it was a bespoke form of NEC4 or an amended form of NEC3 subcontract. The contractor had issued a lot of instructions to omit work from Van Ord, and they excluded approximately 1/3 of their original scope. So the contractor subsequently also sought to reduce the rate they were being paid at. So they were taking the work away and then also the rate. And I think this was on an option B, actually. So bill of quantities. And the contractor, having followed this, having tried to reduce the rate by almost 50%, the subcontractor, Van Ord, rejected, and the subcontract was terminated then by the contractor. So the parties obviously couldn't agree on the valuation of the works on termination, having not agreed previously. Van Ord's position was that the termination account should be valued on the basis of the original tendered blended rate, given that the omission and transfer amounted to a breach of the subcontract. And it also argued that the contractor omitted the easier parts of the work to other subcontractors in order to avoid paying additional standby charges. The contractor argued that the subcontractor had showed poor productivity. They'd have made a loss anyway with that transferred work. So that had led to the transfer of the works, and the reduction in the rate would leave them in no better or worse position. The contract therefore provided a fair and adequate mechanism for omission of work by reducing that rate under 63.10. So this is a Scottish case, and in the Outer House, the court determined that the transfer of the work was a breach of contract. That was established. There was no mechanism or ground for the contractor to omit that work, so it was established to be a breach. And then they stated that notwithstanding that, there was a mechanism to reduce the rate under 63.10. It was applicable to such instructions, and they were entitled to reduce the bill rate accordingly for the remaining works. And the reduction, again, in reinforcing what the contractor had been arguing, it merely reflected what losses that would have been incurred in any event. So, in its appeal to the Inner House in Scotland, Van Ord argued that the contract was being manipulated to suit the interests of the contractor. And had Van Ord known that it was going to be left with a disproportionately higher share of the more difficult work, it would have increased the bill rate to reflect this in its tender. So the court considered the principles that are up on the slide in interpreting the contract, and these are the principles which align, or were stated to align, with the spirit of mutual trust and cooperation. So the first one being that a contracting party shall not be entitled to take advantage of his own breach. A subcontractor is not obliged to obey an instruction issued in breach. And clear language is required to place a contracting party at the mercy of others. So much is made of the principle that a party cannot benefit from its own breach and enforce a clause in its favour, which is not in counterpart. And it was held by the court that clauses 10.1, or the obligation for parties to act in the spirit of mutual trust and cooperation, and 63.10, the mechanism for reducing the rates under the compensation event regime, are counterparts. And unless the contractor had fulfilled its duty to act in the spirit of mutual trust and cooperation, it couldn't seek a reduction in the prices. The court concluded that when properly construed, 63.10 applied only to a lawful change to the works information, and it excluded instructions issued in breach. So in the circumstances, the instructions to omit constituted a breach of contract, and therefore the contractor couldn't seek to rely on 63.10 to reduce the prices. And the court emphasises by stating that the NEC should not be a charter for contract breaking. And so in their comments and the discussion of Clause 10.1, the court then also stated there's a lot of discussion of the spirit of mutual trust and cooperation and what it meant, and the requirement for the parties to act in the spirit of mutual trust and cooperation was stated not to be merely an avowal of aspiration, but it reflects and reinforces the general principles of good faith in contracts. So it's a really good, an important case in giving the spirit of mutual trust and cooperation and good faith in general a leading role in contractual interpretation. It's not merely an aspiration, it's actually a binding obligation. So moving on to the next case, try not to take up too much time, hopefully. These are cases where we're looking at the referral to the courts after an adjudication. So in this case, we had Transport for Greater Manchester engaged Kia to design a bus interchange. The works were delayed, delay damages were applied, there was an adjudication, Kia won, and then they sort of demanded an extension to the time. Well, they got their extension to time to the completion date and repayment of liquidated damages. Transport for Greater Manchester objected. The key point here is that the adjudicated decision is final and binding unless the party serves a notice of dissatisfaction within 4 weeks of notification of the decision. Then Manchester's solicitors sent an email saying that they were intending to seek formal resolution to reverse the outcome of the decision. It was sent by email and post, and they also issued a Part 8 claim seeking final determination of the disputes and reversal of the award. Kia's position was that the court lacked jurisdiction because the notice was invalid, and they claimed the notice was invalid for various reasons, such as it was sent to the wrong address, it included communications to other topics because it also sort of addressed some other issues in that communication, and it did not provide that they intended to refer a specific matter to court. And in the court actually dismissed their arguments and held that the address for delivery was actually valid. The address was actually one that was agreed by the parties subsequently in the adjudication. It wasn't the one that was in 13.2. But the reasoning for this was that the Kia's own notice of adjudication would have been invalid if that had been the case, because that had been sent to the solicitors. The content of the notice, the fact that it referred to carrying on, and it also referred to making a payment in the meantime, it stated that you don't need to set out specific grounds of dispute in the notice, and the fact that it had other matters, they did actually all relate to the same fundamental matter, so that was okay too. It's really just a case that's really highlighting the importance of getting the notices right, making sure that notice of dissatisfaction is issued. And there was another case, the Prater and Sisk case, where Sisk had argued that an adjudicator lacked jurisdiction. It was, I think, after the fourth adjudication, because they looked at and relied on two of the previous decisions where Sisk had actually issued notices of dissatisfaction. And again, as we know, it should be the adjudicated decision is final and binding unless and until revised by the tribunal. But the difference in this case was a notice of dissatisfaction had been served, but it hadn't actually taken any action to refer the matter to the tribunal, which was the court. And therefore, the decisions, the adjudication decisions, were still binding on the parties. This is the last couple of cases, sticking with adjudication and the disputes clauses. This is the Greater Glasgow Health Board and Multiplex case. So this was related to the building of a hospital in Glasgow, an Option C contract, and there were various defects. And then Glasgow, the Health Board, sought to issue proceedings before the end of the limitation period without having referred the dispute to adjudication. And WT clearly states a party does not refer any dispute under or in connection with this contract to the tribunal unless it has first been decided by the adjudicator. And now they tried to argue that the dispute was not one that the parties had anticipated because it could foresee about 22 adjudications to deal with the issues, and they stated it was obviously an inappropriate means of dispute resolution. The proceedings were stayed, and the judge didn't find anything inherent in the claims that would make them unsuitable for adjudication. And he did state that W2 does not exclude complex disputes, and if the parties had intended to exclude complex disputes, they should have stated that in the contract itself. It would have been obvious at the time that they were drafting the contract, and they could have done that expressly. So it was held that W2 acted as a contractual bar to referring the dispute to the tribunal without first adjudicating. And then just a brief mention of this other case, Fraserburg, which is on a similar note, which related to defects at another harbour. Here, it was a similar situation. There were court proceedings alleging a breach of contract without referral to adjudication. At first instance, this was dismissed because, relying on W2, the case should have gone to adjudication first. It was appealed, and although the same principle applied, they should have gone to adjudication before going to the courts, Lord Carloway did find that the proceedings should have been stayed, not dismissed. And he stated that the courts can't entertain the merits of the dispute, but it remains competent to deal with other matters, such as enforcing the parties' agreements. So really that's just a reminder to everybody to follow the W2 and the procedures that are in the contract, and just to point out that they are being upheld by the courts. There are a few other cases which I won't go through. These are really basically just sort of NEC cases, but not necessarily so much on the actual interpretation of core NEC clauses themselves. And then I think we're done. Thank you.